Hello, we're here at Innovista Law, home of the TCPA Defense Force. My name is Ernesto Mendieta.
I'm John Nelson.
Hello, John. Today we're going to talk to you about arbitration agreements and the TCPA. John, I think we can start with the question, what is an arbitration agreement?
Sure. So chances are you've actually probably seen these before in different consumer agreements that you've signed, but essentially what an arbitration agreement is a provision within your terms of service that you have a consumer sign, which acknowledges that the consumer, if they have a issue with your service, cannot sue you in court, that they waive that right and then instead must pursue their claim through arbitration.
Okay, so they're basically waiving their constitutional right to go to court in case of a dispute, and they're going to solve it through arbitration. They're going to have an arbitrator who's going to tell who's right, and they're going to grant some rights.
Correct. So you'll have a private association. The AAA is an example of an arbitration group, which has a cohort of judges arbitrators that will act as though they are a judge in the case, and from that they will help you resolve the dispute.
Okay. Now that we know what an arbitration is, let's talk about the benefits. What would be the benefit of entering into this kind of agreement?
Sure. So really, if you are a brand, a marketer, there are a lot of benefits that come to you in putting an enforceable arbitration agreement in your terms of service. Perhaps the most important is that most typical arbitration provisions, at least the good ones, have a class waiver provision. What this means is that if a consumer has an issue with your text messaging service, they have to come before you individually. They waive their right to bring their claims as a class, as a large group of people. And really what this does is it detracts both plaintiffs and plaintiffs' attorneys from wanting to initiate that suit to begin with, right? Because what that requires is individual select agreements for small sums of money, not providing those large benefits for the plaintiff's attorney that they will get in terms of damages if they're successful in a class waiver.
Of course, because in that case, the plaintiff would have to go for their own claim, meaning $500 per message or $1,500 if it was willful. But that's it. They cannot get together with other class members or appear before you on behalf of representing 1,000, 1,000,000 consumers that receive the same SMS message,
right,
and try to sue you for millions and millions of dollars.
Mm-hmm.
Okay, so first benefit, let's say it's like this barrier that against class actions.
Correct.
Do you have any other benefit you would like to talk about?
Sure, there really are several more too. Another one is that unlike court proceedings, arbitrations are private. This could be very important if you're a highly lucrative, popular brand. You don't want it in the papers that you're being sued or that you've fallen complacent or liable in these areas of the law, especially because that could initiate other plaintiffs to bring about cases. So that confidentiality aspect really can help your brand as it's trying to resolve these problems, trying to better itself in terms of risk mitigation.
Of course. So confidentiality is a very important benefit. I know you started talking that arbitration agreement is part of your terms and conditions, so it's actually a contractual, it's an agreement. So you're able as a company to set up the guidelines on which that arbitration is going to work.
Correct.
What would be your recommendations, or what things are important for the companies to consider when they're drafting their terms and conditions and they want to put that arbitration clause in there?
Sure. Well, I guess the first thing that we need to recognize is that you definitely don't just want to copy and paste these from another brand or consumer's terms of service. You really want to make these specialized and individual because, again, these can be brought under different states have different rules with respect to what an arbitration provision is required to have. So you don't want to be a New York company copying the arbitration provision of a California company. A certain aspect of that provision could not be allowed under New York law. And while you are allowed to craft a lot of the agreement around arbitration as you wish, you of course need to be cognizant of those state laws.
Yeah, so even if these organizations like the AAA have, you can go online to their website and you'll see a standard arbitration agreement. It could work, but it has a minimum requirements. You should still look help from an attorney that knows what you need as a company. The attorney can review your terms and conditions and will let you know what's the best approach to do that.
Correct. And you really do want to make sure the consumer is aware of this. It's always better, from your brand's perspective and from the perspective of the arbitrator and the court, potentially, if it's challenged there, to let them know about it. That's why you'll often see it mentioned at the beginning of the terms of service, and you'll see parts of it at least bolded within the terms of service themselves.
Of course, the least that any company would want is that they actually agreed into an arbitration agreement, but then the court says it's not enforceable.
Correct.
Okay, and just for our viewers, what happens if you have an arbitration agreement, but you still get sued at court?
Sure, and we have seen this happen, many times, and many plaintiffs' attorneys will do this. They will do this, of course, in hopes that either the attorney is not fully aware, the brand is not fully aware about that arbitration provision. But if this suit comes about and you have an arbitration provision in those terms of service, you simply will file a motion to compel arbitration. And that can act as a roadblock. That is really what prevents these plaintiffs' attorneys from bringing these class actions and keeping your brand safe down the road.
And then by order of the judge, the whole procedure will move into arbitration.
Correct.
Okay, thank you, John. I think that was very informative. So that was it for arbitration agreements and the TCPA. My name is Ernesto Mendieta.
I'm John Nelson.
And we're here at Innovista Law, home of the TCPA Defense Force.